Hello, party people, and welcome to Law and Candor, the podcast wholly devoted to pursuing the legal technology revolution. I am Bill, and I'm here with my co-host, Rob. So we've all heard about the extraordinary advancements of AI in our industry. You know, frankly, we talk about it on the pod all the time, but how do you keep up with it? How do you keep ahead of the curve on what's available? Because it is constantly changing. We're going to discuss that topic with Harsha Kurpad today from Latham Watkins. Harsha, he's going to be a great guest. He loves this subject and a really interesting take on this. Looking forward to this conversation. Before we do, though, we have to get to our favorite portion of the show. You know it. You love it.
Sightings of Radical Brilliance.
This is the part of the show, obviously, as you all remember, because your many, many listeners are the biggest fans in the world of the greatest podcast in the history of eDiscovery, where we bring you the latest, greatest news of noteworthy innovation and acts of sheer genius. Today, Roberto and I were reading an article in the New York Times, and I love the title, Using AI to Find Bias in AI. So just if you think about this, that second and sort of the dog chasing his own tail, Rob, let's talk about this article.
Yeah, this is interesting. And it's a recurring issue that we've talked about before, but the article starts off giving an example of, somebody had the idea of creating, an algorithm that would go out and search for nudity and other explicit images on the internet. But the way the process really worked is, anything that algorithm identified was then sent to a team of human reviewers who would look at it and then make decisions on whether it was indecent or not. And of course, there wasn't agreement on what was indecent. And in fact, a lot of things that, I think a lot of people would say have there's no way that that's indecent ended up being classified like that. And again, just kind of showing the problem is that, AI is powerful, but there's real easy ways to introduce bias into it. There was another study that took place back in 2019 in New York where, investigators were looking at one of the health systems and realized that the algorithm that they were using was actually prioritizing care for white patients over black patients. And again, these are things that I don't think anyone intends for this to happen. But these biases creep into AI like they creep into, our own decision making. And it's kind of created this sub-industry of now there's companies that are out there creating technology that look for bias in algorithms. But as Bill mentioned, the irony is that they're actually using AI to do that too. And who knows what kind of bias is creeping into that.
Yeah, exactly. But I think that this is going to become, this is what we're seeing this, in the political world, the right thinks that Facebook and Instagram and Twitter are all creating these algorithms to drive people away from the right. And the left thinks the exact same about the algorithms driving people away from the left, are creating this hysteria. And so we get these fringe groups that are constantly arguing. No matter what side of the aisle you're on, you claim that the algorithms are against you. And so what is the response? The response is to create algorithms to find whether or not there's bias in the algorithms, to confirm or deny your thought that there are bias in the algorithms. And it's just this circular argument. And at which point do you stop the spinning wheel to see where it lands? Because ultimately, is it just ultimately a matter of confirmation bias? And if the algorithm determines that there was bias in the original algorithm that it's analyzing, do you believe it, or do you think it's fake because it's also AI? And if it lands on the side you're hoping it lands on, do you say, see, it was proven true by AI, by the algorithm? So if the bias is proven true, some people will be happy. If the bias is not proven true, other people will be happy. And I'm not quite sure how effective this is going to be because people are challenging the very technology that is doing the analysis.
Well, and to make it more confusing, and now the government's also starting to step in, and the Federal Trade Commission and other agencies are including in their mandate, things that would include looking for bias. And so this is just going to get more and more complicated as time goes on.
And ultimately, if the government's involved as an arbiter, I mean, who's more popular than the government right now? So just adding the fact that we don't trust the technology that's doing the analysis, and we don't trust the people that are using the technology to run the analysis. It's just a mess, and it makes me laugh because there is no truth anymore, right? It's all going to just be whatever your interpretation of it is, and the investigation of that problem is also not viewed in a light that it would be remotely trusted as true if you don't agree with it. Anyway, we digress. Frankly, we should have it. Why don't we have the author of this article on as our next guest on the show? Maybe not our next guest, because our next guest, super excited about. We did have the great pleasure of speaking with Harsha Kurpad. As I said, he's from Latham Watkins, and about how he stays apprised of changes in AI technology in the eDiscovery space, and some of the more advanced tools that are coming out seemingly monthly, and then what's next on the AI horizon, and where he sees, if he could draw up the future, what would be a really cool development in AI that could really just blow the doors off the legal industry. This is a great conversation. We're really looking forward to sharing it with you all. Let's take a listen. Okay, so Harsha, a couple of years ago, we were just asking, we started the podcast, we were just asking people what their, name, rank, and serial number was. And I think I've been saying that for a while. But the truth is, we found it much more interesting. Every time I meet somebody at the cocktail party that's in this industry and I ask them how they got into it, it's a way more interesting answer because nobody grew up wanting to be this, right? So how did you end up in the eDiscovery industry?
Well, not to disappoint, but yeah, just totally by accident. I actually had a separate career before I went to law school. I was in biochemistry. I was going to go the whole science route and decided I didn't want to do that anymore and went to law school, which is kind of odd and crazy. So initially everyone said well, yeah, you're going to be a patent lawyer, right? And I hated doing IP. So I just kind of I wasn't sure what to do. I'd been managing eDiscovery projects. I'm like, oh, okay, this seems okay. And then so I kind of fell into eDiscovery. First at law firms, and then actually I went to the vendor side for a few years and learned all the tech, all the stuff that lawyers hate to learn, like what's a DAT file and all that sort of thing. And then, I actually really enjoyed it, and I actually enjoy the eDiscovery space quite a bit. And I was lucky enough to get recruited to Latham Watkins at the the DC office. And what's really funny is that I started off in practice support, and I was the first lawyer at Latham in that department. And they created a new position. So now I'm technically an eDiscovery case attorney, which is a fancy way of saying I'm a staff associate at Latham Watkins. And so, yeah, I'm loving it. It's a great space to be in, even though it has all the trappings of big law and high stress and all that sort of thing. But yeah, happy accident. And before one quick housekeeping note, the views I express are just my own. I don't express, I don't represent Latham Watkins. Just want to get that piece of.
I do want to say that I do want to extend a congratulations. You've now you've kept that unbroken streak going of being more intelligent and have a better background than either of the hosts. So that has been since the outset. We have never had somebody on that we're smarter than. So I just thank you for keeping that streak going.
And not a particularly high bar, but congratulations anyway.
Thank you. I do what I can.
Yeah. Well, and Harsha, this is one of our favorite subjects. We love talking about AI, and we're pretty immersed in it in our day-to-day life. I thought it might be interesting to start this conversation off by instead of just diving into it, as good as the AI is becoming and the progress that we're making, it still feels like there's some resistance out there in general. And I'm just curious, what are you seeing in the legal market as far as its reception to, AI-based enhancements?
That's an excellent question. It's funny because if you go to any eDiscovery conference over the last, let's say, 7-8 years, even longer perhaps, TAR is at the top of the ticket. Everyone loves to talk about it, but it's really just kind of talking to the same people over and over again in terms of adaptation and what have you. So you're right. Writ large, I think, there is some hesitancy, but I think the nature of the hesitancy is changing. So, the number of people that can say I'm unfamiliar with the technology is dropping, right? Because anyone in the space has learned about, TAR, analytics, all that sort of stuff out the wazoo. But if you're in a certain field of law, for example, if you're doing smaller cases, then TAR may not always be the best use case, right? You can still use it. There's still utility to it. But I think that, it just depends. We have a bias because all we see are big, nasty, fast-moving cases, right? But, I think a lot of practitioners may not cross that bridge, right? And I think, some practitioners are also looking to see where the case law ends up. It's still evolving. That's definitely a thing. But judges are becoming more and more accepting. After Rio Tinto and Judge Peck's opinion, I think that kind of opened the floodgates. But, ultimately, I think the biggest, at least for me, what I've seen at Latham and on my matters, the biggest impediment to using tar is your adversary. It's understanding who you're up against. Like if you're in antitrust merger world and you're dealing with FTC DOJ, tar is perfectly fine. They're on board. They want you to use it. It's kind of becoming more of the state of play, right? But if you're in if you're litigating against a private plaintiff, it just depends on who you're up against. Some people will say, yeah, sure, sounds good. And some people will, even if you elect to disclose, right? That's another topic, entirely. But some people will just fight you tooth and nail, or they'll give you what their canned tar protocol is. And you just know by reading it, this is a non-starter. So it's a combination of the three. I think, again, I'm biased because all I see are nasty, huge, fast-moving cases. So tar is like the first thing I think of. But if you're dealing with like two custodians in a small employment matter, it may not be the best use case. Does that make sense?
Oh, yep, exactly.
Yeah, absolutely. So I think one of the things I want to talk about is, when we're talking about AI, and I think you're right, we're starting to see more and more acceptance of tar after Judge Pack's decision, certainly, and just in terms of there's just the volumes of documents have gotten so big. I mean, I've been in the industry 15 years. I remember when 300 gigs was a big case, right? So it's just gotten so big that eventually technology had to start playing a role in mitigating the amount of eyes that needed to be on doc review. That said, as we get into more AI features, some really advanced AI features, how much is defensibility still a barrier?
I don't think it really is as much as people think it is. I think, if you're really in the know, defensibility is not, it only really comes up in motion practice. And even then there's no great, if I'm a plaintiff's attorney and I'm, yelling and screaming that, oh, your productions are deficient, it's not necessarily the method. You're going to look and see, okay, what am I missing from this production? And then you can address it, right? I think, if they're going to try to attack the algorithm, that's a kind of a loser of an argument, right? I don't think no judge in the country is going to sit there and say, well, I think you're right. The algorithm is just deficient. You know what I mean? I think so. From a defensibility perspective, AI, tar, advanced analytics, I don't really see how you're going to run into defensibility issues. I think what you're going to run into more so than defensibility is convincing a senior partner to use something that they are not familiar with, because they're going to say, what have we done before? That's going to be the first thing that comes out of their their mouth. And that's perfectly reasonable, right? Because they don't want to, no one wants to be first in the industry. No one wants to be the bad guinea pig, if there is such a thing, right?
Just as follow up to that, I guess what I'm wondering is, because in the beginning of tar being accepted before Judge Peck's decision, certainly there was, this is too black box. At least with search terms, we can go back and say, well, what did we leave behind, and do some statistically valid random sampling, right, of what was left behind. Then Judge Peck came out with a decision. But now real AI is developing so quickly, with whether it's natural language processing or
deep learning,
right?
Yeah.
Neural networks are being built. It's getting really deep now. And how much of that is going to be considered black box, or will they challenge it again on defensibility? Like, can you even explain what you're doing? Do you have to get an expert from your vendor? And that's what I'm curious about, because again, tar has become generally accepted because the court said it's acceptable, but courts have not opined on any deep learning neural network. There just hasn't been anything brought yet, to my knowledge. So I'm wondering if it's going to follow the same protocol and just be an extension of tar, or if people are going to say, well, that's too black box of technology for us to give it. And I do take your point that a lot of that will be dependent upon how motion happy the plaintiff is, or how defensive the plaintiff is.
I think it's going to follow tar, right? Like, if someone's going to use it, and then a judge is going to come by and say yay or nay, and that's going to it's going to go probably that route. But I think the other thing to think about here is in the broader world, AI is being used whether we know it or not, whether it's Amazon, Spotify, Pandora, YouTube for that matter, right? And so I think, the more and more, a very clever litigator, I can easily see, but judge, yes, while we're not going to go into the nature of the algorithm, it works just like Spotify. Or something like that.
Or forum shopping.
Yeah.
That's why we're in front of you, Your Honor.
Yeah.
Well, and on top of that, yes, tar has general acceptance. It uses an algorithm that still nobody, 99% of the lawyers can't explain how it works.
Yeah, and if you're getting to that point, it's funny. If you've gotten to that point where you have to actually describe the algorithm, then you've already lost, right? Like, something has gone horribly wrong before you even get there, because most opposing counsel aren't going to attack the algorithm. They'll attack the training of the algorithm, right? They'll just say, oh, well, your definition of responsiveness was just too narrow. You know what I mean? Like, that's the way to do it, because they don't even know the algorithm either, right? So they have to hang their hat on something.
Yeah, I think it's true. And it's interesting as these different AI-based solutions, they're proliferating for sure, more options out there for attorneys to look at. Like Harsha, how do you kind of stay ahead of that and understand, what might be a good option, what's a bad option? What advice do you have for people on how to do that?
I think there's 3 ways to do it. One is just staying ahead. Like, if you subscribe to like legal text newsletter every day, like something like that, like some sort of a trade association, sort of emails or publication that comes out. I think, we are very lucky at Latham. We have our practice support services group, and they're awesome. And they stay on top of this stuff. So if ever I see something that I'm curious about, I'll be like, just pick up the phone and talk to somebody. And then the last but not least is just keep in touch with your vendors, right? Like if someone comes along and says, hey, Harsha, I'm using XYZ tool, that's a great way to stay on top of it. And then, it's a great conversation starter. You're able to ask, well, when have you used it? Have you gone to the mat with it and like in front of a judge? Like, that kind of thing. Because I think depending on the team you're working with, people are open to using something. The question is, and then the first question will always be, well, who's used it before? And how was it used? And did they ever get into trouble? So I think staying on top of your vendors, staying on top of case law and publications, and just talking to other people in the space are the best way to stay abreast of all the stuff that's coming up.
Yeah, that makes sense. So let's talk about, oftentimes these AI solutions, we talk about it all the time internally, oftentimes AI solutions, whether they're out of the box or what they've been developed for, they often find an off-label use, for lack of a better word, right? And so they're often a solution in search of a problem. So are there any data challenges that you're seeing coming up more and more that are getting your clients interested in maybe something beyond TAR or something that's new and cutting edge, because we're dealing with a proliferation of data, or we're dealing with a very unique case? It's not a general litigation, it's investigation. Is there something that from a data challenge perspective that you see could lead to a greater adoption of some of these AI technologies?
I think, yeah. I mean, it's not just the volume of data that's becoming larger. It's the nature of data that's becoming much more complex. Now that we're all in sort of a COVID world, how do you deal with all the collaboration tools that we're using? How do you preserve it? How do you collect it? That's going to be an issue. And then, depending upon the nature of the client, especially if you're working with a tech company or like specific companies that deal in technology or pharmaceuticals or what have you, they may have proprietary databases that you have to pull stuff out of. And that is a really big challenge. And then there's always the Slack and text messages and all that sort of thing. So like any kind of AI, like a deep learning type thing that would be able to get to the most interesting documents or text or Slack or report or what have you faster is the name of the game. Because especially in internal investigations, right? You want to know your bad news or your good news as fast as possible. And like what eDiscovery, like at its heart, really is protecting information and also information retrieval, right? And I think any AI that can do one or both are going to be a game changer. Like I think, like for example, I know this is a little bit more old school, but any AI that can help with privilege identification, whoever can do that will mint money for the rest of their lives, because it's one of those things where that's always the most time-consuming and error-prone part of any eDiscovery project, right? But like, it's also just, I think, to your point, so I have a friend of mine, he's a plant biologist, but he works in AI, so clearly he's the life of the party. And he will tell me, like, there are these weird things that like in deep learning where you can almost have like a pseudo conversation with a computer. Now it's not gonna be perfect. It's not gonna be the interaction with a human being, but like what it's done is it's memorized like all of literature. So if you start mentioning Shakespeare or something, it spits something back at you that's actually quasi like what a person could do. So like, if that sort of thing becomes more commonplace, I'm not saying it's gonna happen anytime soon, but if that becomes sort of where AI goes in the legal space,
sure,
that's going to be like a game changer.
It's going to be interesting to see if AI can evolve, because right now, if having a conversation with AI is equivalent to having a conversation with a plant biologist, it'll be easy to see. Like, what if we can get to somebody who's a lot cooler at a cocktail party than a plant biologist? Because that's where the evolution's going, right? It's just going to get like, soon it's going to be like having a conversation with Bill Clinton, who apparently can talk to anyone about anything.
Yeah, apparently.
Yeah. Let's talk a little. So we talked about some aggressive plaintiffs, and we talked about, depending on who's on the other side. Let's talk about government agencies for a second, because they're starting to educate themselves. The last few years, they've become wildly educated in this area, and they're taking I wouldn't say a tough approach, but they are definitely looking under the hood more than they used to on tar alone. So how do you see, when you're dealing with them during investigations, what do you see? Is there something evolving there? I know, like, for instance, a lot of times now they're asking for a statistically valid random sample of things that have come back responsive. There's nothing in the FRCP that says they can do that. There is actually case law that says they can't do that, but they do it nevertheless. Like, so what are you seeing in terms of how AI is being, or even TAR AI is being looked at, scrutinized from the DOJ or FTC, for instance?
So that's an excellent question. It's a hot topic right now, especially now that the FTC is starting to issue like different or new regulations. So I mean, the starting point here is that the FTC is now becoming more like the DOJ, right? So historically, the FTC has not asked for, like you're saying, like statistically valid random samples of non-responsive documents, right? But now they're doing it. They're also asking questions about like who's training the system, what's the version of whatever tar tool you're using. They're also going to be asking, like, are you going to incorporate certain data types into tar, which historically they have never asked, right? Like, they're specifically very curious about Slack and text messages, how you're going to treat them. So they're getting wise, and I think it's also to their advantage, right? Because two different things, right? For all of us who have done second requests, we all know that they're fast moving and large, right? And it's not like we're giving them lots of information, and and we know they don't have the manpower to go through millions of documents or hundreds of thousands of documents. So they're using TAR or AI or some sort of system to find what they need to go through their process, right? And they're in the space, so they're going to hire who they can afford to hire, and they're going to come with their TAR tools. And sorry, go ahead.
And not just that, but part of their mandate is to make this process easier on the parties that are going through it.
Yeah.
It doesn't feel like it sometimes, but but yeah, I mean, they need to not going to editorialize on who's running what, but the issue just becomes like, it's in their best interest to either come up with a yes or no answer on a merger, right? As soon as they can.
Yes. Right.
And, how that actually ends up going is a completely, that's a topic for a different time. But that being said, they need to get to it quickly. And if people are complying in 2 to 3 months, so 60 to 90 days, and then there's only like X amount of time on the back end to close the deal, they need to move quickly too.
Yeah, for sure. I think another thing that, every industry has to go through is how they're going to apply these different types of AI. In marketing, they were early, I think, into looking at the potential of AI and realizing that you could use that for customer segmentation, identifying your most valuable customers. We'll have to do the same thing in legal now. And whether it's, classification or deep learning, there's a lot of different terms that are kind of out there. But Harsha, what do you see as the real practical opportunities for, whatever the method or the technology you're using? What do you think is the best application for this?
I think using AI to I would say there's a few use cases. One is the classical one: too much data, not enough time. Right? That's going to be the one where you want to use some sort of an analytics, because if you go too old school, you end up costing your client way too much money, right? And I think and some clients don't even want you. Like, some clients, I'd say they come in different categories, right? Some clients are very much like, we use AI all the time, you should use it too. Right? Some are going to be sort of agnostic and say, hey, we defer to you as the legal, folks. You just, go with what you know. And some are just like, I don't know what this is. I'm not really sure you want to use. And you find on the client side, you're going to find that too. But more and more, it's going to the two categories: agnostic or rah, go for it. Right? And I think that ultimately, too much data, too little time, or if you have a hot investigation, I think one of the best uses of like continuous active learning or feeding hot documents into a system are for like FRCP investigations or like investigations where like there could be potential bad conduct. Like that is something where I think it's an underutilized thing, like using analytics and TAR or AI to look for good or bad documents. I think that's something that is a little underutilized. It makes sense why it is, because usually, you're flying through depot prep, you're really trying to prepare a witness and go for it. So you're not thinking about the analytics aspect of it, right? But if you take a step back, you might be able to say, hey, how can I use this to get to like a good or a bad document quickly? And the other thing is, especially in the investigation context, if you're doing some work before a regulator gets involved and you're trying to find out, like, did someone really screw up here? That's where analytics can be a real benefit.
So we've talked about different ways that different models that are available and different ways of using them, and how the opposing side, whether it's a government agency or plaintiff, will approach them, attack them, or poke holes in them, or accept them. Let's talk a little bit about training the algorithm. So do you have any best practices for training algorithms, and then also staying on top? You talked about earlier about staying on top of new technologies that are out there, but also staying on top of different training mechanisms or processes for training some of these algorithms.
That's a great question. So there's a couple of different ways to slice that up, right? I think historically, if you're doing TAR 1.0 with a regulator in an antitrust matter, in an ideal world, you have one person sitting there training the model. That never happens anymore because it's just too many documents. I mean, it'll take the poor person weeks, and their eyes will start bleeding and all that sort of thing. So the way to do it is close-knit teams, lots of communication. I know it's harder to do in COVID, but like really have like in the old days, it'd be a war room of like 5 associates, or not maybe not 5, but like 3 to 5 people, just heads down, asking lots of questions. I think now it's still just as important to do something like that, because the more you can train a TAR algorithm, if you're using 1.0 especially, is super important. Yeah. If you're using 2.0,
it's a lot more to review.
It's a lot more to review, but it's also a little bit different, right? Because then you can use contract attorneys, or you can just have a boldly go where no one's gone before and have like 5 associates go through a few thousand documents and see what happens and see how it starts to sort of stratify and cluster and not cluster, but like, rank the documents. And but I think training the algorithm is super critically important. Being aligned, understanding what is and what's in scope and what isn't, having lots of conversations about it. And honestly, setting aside the time. I think the one thing I always tell my teams, regardless of whichever tool they're using, is like, listen, it's going to take time. You can't just do this on a Wednesday night and be done with it. Like, it's going to be one of those things where it's going to take time, effort, energy. You may have to, and I think that's where I think things can go a little bit wrong. You need to be able to have a cohesive team and attack it that way. And also just be realistic with people. Hey, you're going to be reviewing 6 to 12,000 docs or whatever that may be to help go with the system. The other thing to do is just like the same with the contract review team, right? Like, start small team and just let them rip on the documents and just really supervise them. Like, if you're doing a 2.0 especially, that's the way to do it.
Yeah, agree. Maybe we just finish with one question. If you look out there in the horizon, and do you see one super interesting thing that you think AI will be able to address, even if it's not something we're thinking about right now?
Oh, that's an excellent question. I think any AI that can parse privilege or parse like low text documents like Slack and IMs and stuff like that, or the one that can figure out like, because I would honestly, what I would love to do is like, let's just take the merger context for the sake of argument, right? If I can write a paragraph, that would be like the worst thing ever that a regulator could see, and then say, hey, program, go find something like this. That would be brilliant. Because like, if you invent your own bad doc,
which you actually can.
Yeah.
And I mean, it is a process that people use sometimes, but yeah.
If it does, if that could pull it back accurately, that would be cool.
It'd be huge.
At Lighthouse, we commonly go to Bill's laptop and we pull out examples of documents that, the worst thing you could find. And sure enough.
Find these for violation of all kinds of HR nightmare. Here's Bill's laptop. All right, so I am going to try, and I am bad at this, but this has been, I have to say, I think, Rob, you probably agree, this has been one of my favorite pods. First of all, I love the subject matter. You were a fantastic guest. You had the deep knowledge here. I don't even know if we stuck to any, we were all over the place, but it was all great. So I am going to really try to summarize this stuff for our listeners. So in terms of barriers to AI, defensibility, not huge, right? Because what we're talking about here is it's going to get that extension of TAR. TAR has sort of been blessed at this point by court decisions. And this is going to get that extension of, it wasn't just TAR that was blessed, but leveraging technology, which was blessed. And so AI is going to sort of fall under that, and if you are going to sort of challenge it, are you going to challenge the algorithm? No, you're probably not going to challenge the algorithm. What you're going to attack is the training. And that's what I think we've seen with the agencies. In terms of staying apprised of what's out there in the market, it's just staying apprised by keeping in touch with your vendors, keeping in touch with people internally that sees the various technologies and different publications where this stuff is talked about. In terms of what drives use of this technology, it's not just volume. I thought this was a great point. Not just volume, but different data types. I think it's different sources of data. We're beyond the fact that we're just using emails, PDFs, and Word documents and spreadsheets these days. Right now, we're starting to see so many collaboration platforms. People that are really leveraging AI to get to the responsive docs within these different platforms, I think are going to have a heads up or an advantage. In terms of agencies, we touched on this briefly. The FTC is really caught up to the DOJ. The DOJ was always seemed to be more out in front in terms of applying scrutiny, having an expertise around TAR and AI. The FTC is really catching up here. And I think that between those two agencies, they're forcing you to know your stuff, frankly. You need to know your stuff. You need to be able to defend your process more than the technology. You've got to defend your process. In terms of training the algorithms, I thought touching on this was interesting. If it's a 1.0, I think in either case, you want to keep a close-knit team and lots of communication, for instance. But you're going to need a bigger team if it's 2.0, because there's a lot more to review. A smaller team if it's 1.0, but either way, you want to keep lots of communication, whether it's a close-knit team on 1.0 or a larger doc review, team of doc reviewers at 2.0. Lots of communication is important because you want to give consistent messaging to the algorithm. And then I think, in terms of the future and whether or not this is going to be possible, it's starting to get really good around developing AI if you create a bad document. It's no shock. This stuff is developing faster than the market can keep up. It's certainly faster than judges will accept. So it's interesting that, because legal has really not been at the forefront of this. It's like I think Rob mentioned earlier, marketing has things like that are capitalizing on AI to generate revenue, whereas this is really to save money. On the doc review side, save money, keeping eyes off documents. When you can leverage AI to generate revenue, you've seen that much more. Leverage much more, like with Facebook and Target and Walmart and things like that. Amazon, legal's woefully behind this area, but we are starting to see a catch up in terms of adoption. This has been great. Really, really, really appreciate this. I think there's no way a plant biologist would have been half as interesting as you. No offense to your friend.
Yeah,
he's good people. He's good people.
Agreed.
Really appreciate this, Harsha. We were looking forward to this one just from the subject matter, but you were a fantastic guest. I think our listeners are going to love this pod.
Well, thank you for having me. I loved it. You were great to chat with, and happy to be back if ever that opportunity ever comes up. So
Absolutely.
Love it.
Thanks so much.
Again.
Cheers.
Can't get enough of Law and Candor? Be sure to subscribe. Follow us. Follow us on Twitter, any social media outlet that you can think of. We're happy to post future updates, news, and as always, we appreciate any ratings. Thank you again.